Initially, in September, October, and November of last year, as many of you know, we convened regular weekly meetings with various members of the criminal justice system, prosecutors, defense attorneys, representatives of private attorneys, law enforcement officials, folks from the Department of Probation, from the Department of Corrections, from the Executive Office of Public Safety, various individuals within the criminal justice system. And we exchanged information. And we sat around a table much like this, and we discussed names and data and information. And we discussed issues that were then arising, factual issues, legal issues, ethical issues that were arising as we exchanged information. And within a very short period of approximately 30 to 45 days, through the cooperation of all of the individuals in the criminal justice system, we were able to identify approximately 2,000 individuals who were then in custody or incarcerated, whose drug samples were in some way associated with testing done by Annie Dukin. Now, those were individuals in state or federal custody who were either serving a sentence on a drug case associated with Ms. Dukin, or were being held on bail, now awaiting trial or then awaiting trial on a drug case associated with Ms. Dukin. And we distributed to prosecutors and defense attorneys and to the court system a list of those approximately 2,000 individuals, and they were addressed by prosecutors, by defense attorneys, and by judges in a very expeditious way. Special sessions were set up in each of the counties that were affected, and those individuals were brought as expeditiously as possible before the court. We continued meeting, and we continued to exchange data and information throughout the fall and into the winter of 2012, and we explored names of individuals who were otherwise severely impacted but were not incarcerated, individuals who were on parole, individuals who were on probation, individuals who had previously been convicted of a Superior Court case in which chemist Annie Dukin had been associated with the drug samples. And in all told, by the end of December of 2012, some 3 months into our assignment, we had identified approximately 10,000 individuals whose drug samples were associated in some way with testing done by chemist Annie Dukin at the drug laboratory. That information, that list of approximately 10,000 people, including adults and including juveniles who had passed through the juvenile court or had been found delinquent and perhaps committed to the Department of Youth Services, were provided to all of the prosecutors, all of the defense attorneys, and throughout the court system. Beginning in January and into February and March of this year, we turned our attention to trying to do what we could to identify each and every individual beyond those that we had. And we systematically performed what we described as a file-by-file review. We physically examined evidence control cards, drug receipts, chain of custody forms, by going to the crime laboratory, by looking at documents, and by methodically turning over page by page as many laboratory documents as we could in order to determine whether or not there were additional names, and if so, whether they had been prosecuted in the Superior Court or the District Court. Beginning in April and May and into the early spring, we continued those efforts. At or around the same time, an outside document collection vendor, a company called Navigant, began their work in collecting, scanning, organizing, and with us analyzing all of the laboratory documents, not just the evidence control cards or the drug receipts or the chain of custody forms, but also all of the documents contained in the laboratory. As of July of this year, we had collected and scanned and analyzed approximately 3.5 million documents from the Hinton laboratory. And again, we continued to try to evaluate and determine the identity of additional individuals. We looked at the original database, which had generated the list in September of 2012. And that list, as many of you know, was based on an approximate number of samples that Ms. Dukin had allegedly tested over the course of her career from 2003 to the present. And based on those samples, laboratory officials estimated that she had come in contact with samples associated with approximately 34 or 35 or 36,000 individuals. Well, based on our individual file-by-file or by-hand review earlier this year, and based upon our review and analysis of all of the data and information and documents at the laboratory, we are now able to say that that initial file, that initial list that was generated in early September of 2012 actually, in truth, contained approximately 37,500 names. And as I said, and as you know, that list and that information was provided to prosecutors and defense attorneys and various other agencies and offices in the criminal justice system throughout the fall of last year. In addition, as a result of our file-by-file review and our examining documents by hand, we continued to search for additional names. And in particular, we looked at those names where there had been a single entry, but a suggestion that there were other defendants, such as co-defendants, or et als, or et ceteras, or other individuals whose names might not have appeared on the original database that generated the list in September. And by looking at all of the laboratory documents, we were able to generate an additional approximately 2,500 names based upon review of all the documents. And therefore, we were able to say that as of today, there are approximately 40,000 names of individuals whose drug samples were associated with chemist Annie Dukin in some way. That's a broad overview of the path and the course and the nature and extent of the work that we performed over the last 10 or 11 months. That work and those three phases are embodied in the report and the results and the findings which we submitted to Governor Patrick today. Throughout the process from late September through August, I either met regularly with Governor Patrick or members of our team, and we communicated regularly in keeping him apprised and updated of the status of our review and the numbers. Today we have a list of some 40,000 individuals, approximately, as I said, 2,500 additional names from the original list generated in September or October. In the coming days, I plan to sit down with representatives from the Committee for Public Counsel Services, private bar associations, the Massachusetts Bar Association, the Boston Bar Association, district attorneys, prosecutors, both in state and federal court, and chief justices of the various courts, in order to describe the list to them, provide the information to them, and do what we can to assist them in doing exactly what the governor said was the purpose of this task force back in September and October of last year, and that is to get the information into the hands of the appropriate people, prosecutors, defense attorneys, and judges, so that fundamental fairness and justice can be done in the courtrooms.
Mr. Meier, how many of these 40,000 are currently incarcerated?
As I said, our review and our identification indicated within 30 to 45 days that approximately 2,000 of them were incarcerated. Those were identified right away as quickly as possible.
And what is the common denominator? Just that she was involved in the case, or was there more to it, an articulable or a level of involvement?
Again, most respectfully, my role was confined and focused to identifying individuals. As you know, the Attorney General's office is investigating and prosecuting Ms. Dukin for her alleged conduct, and the Inspector General's office is conducting a more thorough overall evaluation of the laboratory. I'm not here to address individual procedures or policies of Ms. Dukin or anyone else at the laboratory.
These are all cases that she touched?
Yes.
Mr. Meier, so in terms of this database that's being created for prosecutors, defense attorneys, and people of law enforcement, things like that, is it currently available now, or is it going to be available?
As of this afternoon, the database is going to be provided to prosecutors, defense attorneys, the court system, and others within the criminal justice system. For obvious reasons, since the database contains defendants' names and privileged confidential law enforcement information, it's not going to be made available to the general public. In the report that I submitted to the governor this morning, I have attached, and I will do my best to make available to you, a sample or fabricated list or copy of what that list embodies. The names are not real names. The police officers' names are not real names. The laboratory numbers are not real names. But that exhibit or that attachment to our report accurately reflects the actual master list that will be given to folks within the criminal justice system.
So as a result of this entire catalog being available to law enforcement, the latest estimate we got was that just under 300 people have been released from prison or from jail. That number should go up then, correct, or not?
Respectfully, I can't speculate on what's going to happen in the court system. That's not my role.
Cases that you've looked at and reviewed, potentially there should be more people's cases overturned, their appeals, reheard, et cetera. People released from jail, no?
Again, my job is to get the information into the hands of the prosecutors and defense attorneys, and perhaps most importantly, the judges who will ultimately make those decisions.
There were 286 people as of February. Do you know what the current number is in terms of people released?
I do not. I'm sorry.
You know how many of these cases that are there, the 40,000, have at least been given some sort of review by law enforcement? Obviously, you put them together and pass them to them. Is there a percentage of them that have already been looked at, a percentage that hasn't already been looked at?
As I indicated to the governor in my actual report, which hopefully will be made available in some form to each of you, approximately 2,600 cases or hearings have been held in the Superior Court alone. So that of the 40,000, there have been at least 2,600 court hearings in the Superior Court, and that doesn't include the District Court. And as I point out, or as we point out in our report, and as I think many of you know because we've discussed this before, to the extent that 10,000 priority individuals were identified by December, 2,000 of whom were individuals associated with being in custody within 30 to 45 days, those were the most severely impacted. Those were folks who had lost their liberty, were serving a sentence, or held on bail. The vast majority of these individuals, and the report points this out, the vast majority of these individuals, whether the original 37,500 or the additional 2,500, are individuals who were charged with and presumably prosecuted in the local district courts or the Boston Municipal Court for first offense minor possessory offenses. But we recognize, and the governor surely recognized back in September, that it's equally important that each of these individuals be identified and that information about each of them, regardless of whether they were incarcerated in 2012 or had a case in 2004, to the extent that Annie Dukin was associated with those cases, it was equally critical that we get the information about those cases into the hands of prosecutors and defense attorneys.
So you said that, I just want to clarify this. You said that the first 2,000 were taken care of originally. So it seems to me that most of the people that were already in jail, their cases had been heard. So it's unlikely with this list being released to law enforcement that there are people who are still in custody whose cases have not yet been dealt with. Is that fair to say?
Again, I can't speculate. I can tell you that it was the governor's priority and everyone's priority that within 30 to 45 days we had done everything we could to identify those individuals who were then in custody, and that's exactly what we did.
You said that there were 2,600 people.
Associated with Annie Dukin, were they from anything from Western Massachusetts or the other states?
No, I'm sorry. As the report makes clear, the affected counties were Essex County, Suffolk County, Middlesex County, Norfolk County, Plymouth County, Bristol County, and the Cape and Islands. That is 7 different counties.
Have the 40,000 been notified individually that they that their cases have involvement with Dukin?
The way the process works as a result of the meetings we had in September and October was that the list was provided to prosecutors and defense attorneys and other law enforcement officials and other individuals within the criminal justice system. To the extent that an individual believes that he or she may have been affected by Ms. Dukin, what that individual has done or presumably will do is to contact his or her attorney or contact the Massachusetts Bar Association or contact the local district attorney's office or contact the Committee for Public Counsel Services. It's through the lawyers that the information is being distributed.
And just to be clear, you said 2,600 cases have been heard, and yet there are 10,000 priority cases. So does that suggest that of the 10,000, only a fraction have actually come before the court?
Again, I can't speculate on what lawyers have done when they've reviewed those individual cases. The 2,600 are in the Superior Court alone. Again, as the report indicates, and as I've said, the vast majority of these individuals, beyond the 10,000 that were identified, the most severely impacted that were identified by December, the vast majority are individuals who were charged and prosecuted in the district courts, or the Boston Municipal Court, in those 7 affected counties, going back to 2003. But as I said before, the governor and our task force felt equally strong and equally concerned that the information regarding each of those individuals be distributed as well.
Can you be more precise than
Yeah.
20? Can you be more precise than just vast majority?
Yeah, how many, yeah.
Again, I can't speculate. That's up to the individual.
You said the vast majority are in district court. Well, what's the vast majority? We're talking 20,000, 25,000? What's that actual, that number?
I would hesitate to put a number on it. That's going to be up to the individual, district attorneys' offices and defense attorneys in the court system.
David, is this like a monopoly game, like get out of jail pass for all these people, these 40,000 people? Are they cheering at home going, I'm going to get out of jail?
Again, as I indicated a little while ago, you know what my role is and my focus, and most respectfully, I'm not going to speculate on what any DA's office or defense attorney or judge is going to do on any given case. That's not my role. That's not my responsibility.
So that were released, do you know how many roughly have been brought back to jail?
I'm sorry, I missed the first part of the question.
Of the roughly 300 folks who've been released, do you know about how many have reoffended or been brought back?
I do not know, and that was not part of my mission.
All right, thanks everybody. For folks who are curious about cost, Alex Zeroulis from ANF has a table for folks that breaks this down. David will be available for some one-on-ones afterwards if folks have follow-up questions.
We all have the same question. We're sort of,
All right, 3 more questions and then we're done.
Say something you don't want to say. I'm just sort of unclear. You used to be an assistant DA. You know how the system works. Are you saying most of the people that were already in prison probably have had their cases dealt with? It's unlikely that more people are going to be released because there were only 2,000 that were in custody at the time, and you put those names up front. So is it fair to say that if they got out, if they were going to get out, they probably had their cases heard and dealt with at this point?
Again,
There's no more number of surprises left.
I understand the question, but respectfully, you have to appreciate the position or my role. I'm not a prosecutor, I'm not a defense attorney, and I'm certainly not a judge. And I can't speculate on what's going to happen this afternoon, never mind tomorrow, next week, next month, on any given case. And I leave that to those far more experienced in these individual cases.
Can you give us your impressions of the findings that you did? I mean, I know you're sort of fact finder. What did you find? Anything surprise you, or whatever, in terms of what you discovered?
Again, respectfully, that's not why I'm here today, and that's not what my role was.
Are you aware of any precedent for this, for the scale of it, the nature of it?
Again, I appreciate the question, but that's not part of my role.
I know your role was to look at the Dukin case, but is there anything that you discovered that would lead you to believe that this went beyond any Dukin?
Again, as I said earlier, the alleged conduct of Ms. Dukin, the nature and scope of that, is being thoroughly investigated and prosecuted by the Attorney General's office, and the nature and extent of the policies, procedures, practices at the Hinton Laboratory overall is the subject of an ongoing investigation by the Inspector General's office.
Thank you, David. Thanks everyone for your time.
Thank you all.